The chair now recognizes the gentleman from Vermont. The chair now recognizes the gentleman from Vermont. Is it a different state? Does the gentleman seek recognition?
I don't, but I'll take it.
The gentleman is recognized.
It's always good to be here.
If you want to move the previous question, you're welcome. Would the gentleman like to reserve at this time?
I will yield.
The gentleman yields to the ranking member.
Thank you. But I appreciate the effort, Mr. Chairman.
I thank the gentleman for yielding. You know, we've heard a lot of discussion today about Ms. Lerner. And, you know, I was listening to Mr. Duncan, who I have a tremendous amount of respect for. And as he talked about the whole idea of someone coming in and making a statement and then asserting their rights under the Fifth Amendment. And, you know, I don't think the Founding Fathers were about the business of a gotcha type of situation. Rights are very special things. They are, as the chairman said when he began this hearing, and I have a respect for him for saying it, that this situation should not be taken lightly. And I think that, you know, every time I sit in hearings like this, you know, I have to try to make sure that I get past the politics and try to figure out, number one, what is right. And I also think about how we will be viewed. There's been a lot of discussion about all the wrong that Ms. Lerner did, the alleged wrong. And I want to be clear, I really would love to hear her testimony. I would love to hear even some of the answers to the things that my good friend Mr. Gowdy presented, because they are legitimate questions. They are questions that will allow this committee to do its work most effectively and efficiently. And I think we all deserve to hear those answers. But there comes a point in time when certain things trump other things. And in this instance, the idea that there are rights that one can assert not to incriminate herself, I think we have to deal with that first. As I said in my opening statement, it's not about, this is bigger than us. It's bigger than this moment. It's bigger than Ms. Lerner. It's about generations yet unborn. And I think somebody, I think it was Mr. Connolly, who asked the question, and it was, although people laughed, it was a serious question. When people come before this committee in the future, will we have to read them their rights? Will we have to say to them, give them more like a Miranda warning type right statement? Will we have to tell them that any syllable that's said may very well be used against them? And I think we really have to be very, very careful in the precedent that we're setting. There will be disagreements with regard to the law. After practicing over 20 years, I had a lot of disagreements with lawyers. I remember in law school, we would argue cases in moot court, and one person would look at the same facts and have one opinion, somebody else would look at them and have another. But no matter how you look at the facts, the thing that must prevail are the rights of the American people. That's what this is all about, the rights. And so as Mr. Duncan spoke, I thought about some of the criminals that I've come across. I mean, some rough people, but they still had rights because they were still Americans. And that's the wonderful thing about this country. And I'll close with this and remind all of us that this is our watch. We're on the earth today, and I think it is so important that we pass on a democracy to our children and our children's children that's strong, that's just as strong as the one that existed the day we were born. With that, I yield back.
I thank the gentleman. We now go to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. When Mr. Cummings talks about rights, Mr. Chairman, I'll listen. I'll listen because he was a very, very good attorney. I'll listen because I am familiar with his personal narrative. And while he was talking, I scribbled down, of course he's right. You have a right to remain silent. You also have a right to confront your witnesses. That right is in the exact same document that the right to remain silent is in. You have a right to cross-examine witnesses, Mr. Chairman, and I think it's important for us to spend just a minute on why our framers thought it was so important that you be able to confront and cross-examine witnesses, because it is the single best way to elicit the truth. Yes, you have a right to remain silent. You also have a right to a jury trial, but it's waived every day across this country. When you plead guilty, that is a waiver of your right to a jury trial. You have a right to counsel in felony cases. People waive it all the time and make the mistake of representing themselves. So when we're going to talk about rights, let's talk about all the rights, including the right to confront witnesses and cross-examine witnesses, Mr. Chairman. And it's important that we understand why we were given those rights. Ms. Lerner is an attorney. She's not like the folks that Mr. Cummings represented or the folks that I prosecuted. She's an attorney, and she had an attorney sitting behind her. And some of my colleagues on the other side this morning, Mr. Chairman, and you heard them, they said we need another hearing where we can bring in experts. Well, let me take out all the drama from what that hearing would be like. We would pick 3 that said she waived, and they would pick 1 that said she didn't. Okay? I hate to do a spoiler, but that's the way that hearing would go. We would find 3 that said she waived, and you would find 1 that said she didn't. So we'd be right back where we are now, which is us having to make the decision. Or, Mr. Chairman, we can go to the language of the Supreme Court, which is kind of the ultimate expert. I would argue it is well established that a witness in a single proceeding may not testify voluntarily about a subject and then invoke the privilege against self-incrimination when questioned about the details. And the Supreme Court continued, in such a case, the privilege is waived for the matters to which the witness testifies, and the scope of the waiver is determined by the scope of the relevant cross-examination. What that says, Mr. Chairman, is you do have a right to remain silent. But when you talk, not some talismanic recitation of words which they're saying you should have done, some rote liturgy that you have to repeat to a lawyer who knows her Fifth Amendment right as well as you do. But when you waive by testifying, you subject yourself to cross-examination. And that is true for every client that Mr. Cummings had. It is true for every sexual assault victim that I had to call as a witness. They couldn't give their version of what happened and then not stand for cross-examination. That's not the way the system is set up. And it's not set up that way because the purpose is to elicit the truth. So, Mr. Chairman, I'm going to simply ask this. This is what she said when she came before our committee. 17 separate factual assertions. If this is not testimony, can someone on the other side of the aisle please tell me what is? Does it have to be 20 factual assertions? 25? What constitutes testimony to you? If what she said and the pervasiveness of her testimony, 17 separate factual assertions, if that is not testimony, then tell me what is. And if that's not waiver, then tell me what is. Mr. Chairman, there have been a lot of conversations about rights. Most of the conversations have been about Ms. Lerner's rights. But that same document gives you the right to free speech and the right to petition your government for redress. And while Ms. Lerner may have waived her right, our fellow citizens did not. And the only way we're going to find out what happened is if she answers our questions. Not just says, I did nothing wrong, but answer the questions that all of you agree are legitimate questions. If this isn't waiver, tell me what is. And if that wasn't testimony, then please explain to me what would constitute it in your mind.
The gentleman yields back. Who seeks recognition? The gentleman is recognized. Mr. Cardeas.
Thank you very much, Mr. Chairman. I just want to remind the viewers of this committee and the members of this committee of a few occurrences that occurred in and around this issue that we're covering today. Chairman Issa would not and did not accept a one-week extension request from American citizen Lerner. Also, Chairman Issa chose to go on national television and began to misrepresent facts about what occurred in the IRS. One thing that I do agree on is that 298 applications were not handled properly, overly scrutinized. But yet 96 of those applications were considered applications that were of Tea Party ilk or to the right or what have you. But yet Chairman Issa chose to hold a hearing that only wanted to look at or consider those applications that were either mishandled or overanalyzed or delayed beyond reason. He only wanted to have hearings about 1 out of 3 applications, 96 applications out of 298. With that in mind, ladies and gentlemen, American citizen Lerner had much reason to be concerned that coming to this hearing, this committee of the United States Congress, was not a hearing that was going to be fair or a hearing that was interested in the truth, but a hearing that was interested in playing out politics, both on national television and in this formal committee. Lois Lerner is an American who's being treated in a way that no American should ever be treated by any authority, much less the United States Congress. And I just wanted to state for the record, I'm proud to be a United States Congressman elected by the people of my district and to do the business of moving this country forward. But I believe that this committee on this day is going in the wrong direction, and this is a sad day for the United States Congress, and it's a sad day for the United States of America when an American citizen's rights are being trampled. I yield back.
The gentleman yields back. We now go to the gentleman from Washington, Mr. Hastings. But before you begin, upon completion of those who feel they must speak on this, we're going to encourage a previous question, and I've been informed there will be a unanimous consent. So do not feel that you have a need to speak more unless you have something you believe you want to say, but everyone will be given that opportunity. Mr. Hastings.
Thank you, Mr. Chairman, very much. Let me broaden this argument, this debate a little bit. Our country was founded on the basic principle that citizens would not be persecuted by the government for their beliefs or political affiliations. That is why when concerns were raised in early 2012 that IRS officials were targeting conservative groups applying for tax-exempt status, several committees of the House of Representatives, including this committee, began asking questions and investigating those allegations. Unfortunately, when Lois Lerner testified before this committee in May 2013 and again last month, she refused to answer questions that would give us, members of Congress, the necessary information to evaluate the degree of wrongdoing at the IRS. Mr. Chairman, Congress has a clear constitutional duty to conduct robust oversight of the executive branch, and the IRS is part of that branch. Congress has exercised its oversight authority since the earliest days of our nation, dating back to as early as 1792, when a committee was established to examine the Army's defeat at the Battle of Wabash. Throughout each generation, robust congressional oversight has exposed waste in government and abuses in power by administration officials and even presidents. It is through Congress asking tough questions and conducting their oversight duties that allow Americans to hold their government and elected officials accountable. I am disappointed that this administration appears so willing to jeopardize the public's trust in their government they have not been more forthcoming with information related to this investigation and others. Mr. Chairman, as Chairman of the Committee on Natural Resources, I have overseen numerous oversight investigations into this administration. I can tell you firsthand that it has failed to live up to its promise of being the most open and transparent administration in history. In the course of our committee's oversight, the administration has slow-walked numerous requests, waiting months for turning over any requested documents. And when documents are provided, they are often copies of what already has been released to the public under the Freedom of Information Act, or they are heavily redacted. This lack of cooperation undermines Congress's constitutional obligation to conduct oversight as a co-equal branch of government. This administration seems to be saying, "Trust us, there is nothing to see here." But as President Reagan said in another context, we should trust but verify. And that is what we are trying to do with our oversight. Through our oversight responsibilities, the Natural Resources Committee has found troubling examples of this administration's decisions being based on politics rather than the law. This includes how conflicts of interest are handled for political appointees, how the lack of sound science is used in endangered species listings, and the mismanagement of the process to rewrite coal regulation. Now, Mr. Chairman, I understand that issuing a subpoena is never the preferred option, and it is unfortunate that I have had to do so in my committee on several occasions. So I fully understand that the vote today to hold Lois Lerner in contempt is not one to be taken lightly. But, Mr. Chairman, it must be taken, given her ongoing refusal to cooperate with this committee's investigation and Congress's constitutional obligations to ensure that the laws are being faithfully executed. I yield back the balance of my time.
The gentleman yields back. Does anyone else seek recognition? Gentleman seek recognition? You are recognized for 5 minutes.
Yield my 5 minutes to the ranking member.
I want to thank the gentleman for yielding. I want to, Mr. Chairman, I have a unanimous consent request.
Reserving the right.
The gentleman's state is unanimous consent request.
Thank you very much, Mr. Chairman. Chairman, I have a request that I hope every member of this committee can support, and I will just take a moment to describe it. Can we please have the staff bring in the documents I want to discuss? Mr. Chairman, clearly we do not support this contempt resolution. Based on the assessments from more than 30 independent experts, we believe a Federal court will dismiss this case as legally deficient. We do, however, support transparency. And we do want the American people to have the whole truth and nothing but the truth. These are the full transcripts from all of the interviews our committees conducted during this investigation. We have, and these are witnesses called by the majority, we've interviewed IRS employees from Cincinnati, IRS employees from Washington, and even Treasury Department employees. Last year, on June 9th, I sent a letter requesting that you, quote, release publicly the transcripts of all interviews conducted by committee staff. This month, you stated on national television, and I quote, these transcripts will be made public. It has now been more than 9 months, and it's time to make these transcripts public. In the past, you've said making the transcripts public would give witnesses a roadmap to our investigation. But you've already crossed that bridge many times. Release selected quotes from these transcripts in reports, press releases, memos, and letters on more than a dozen occasions. You also let reporters come into the committee offices to read full copies of select transcripts that you chose to make available. The full transcripts in their entirety show exactly how the employees in the Cincinnati first developed the inappropriate criteria, and they also show how Lois Lerner failed to discover them for more than a year. They certainly show mismanagement at the IRS, but they show no White House involvement and no political motivation, contrary to the claims of the Republicans. It's time to put our whole story out there so the public can see everything, not just cherry-picked pieces. So I ask unanimous consent that the committee release publicly full copies of all these interview transcripts no later than May 1st. And I want to emphasize this, along with any specific redactions that the Chairman Issa, concludes are appropriate. Mr. Chairman, before I yield back, today is a very important day, a historic day, and I know other members may want to be heard on that.
Yes. If the gentleman would yield.
Yes.
I cannot support releasing the documents in their entirety at this time for two reasons. First of all, the gentleman has the absolute right to select documents and use it in reports and other appropriate material, and I encourage you to do so. But as I've said previously, it is ill-advised, and I would ask you to restrain and other members to restrain themselves from releasing these documents in their entirety, because it does provide a roadmap as to the questions and answers. However, it is my intention to release redacted versions of all interviews once we have, one, completed all interviews, and two, after the discovery process has been delivered to us. And I might particularly note that just a few days ago, the Commissioner told us it might take 2 years to get us documents. But it should take dramatically less time to give us, for example, all of Lois Lerner's emails. Once we have substantially received those sorts of documents, which I expect to be, I hope to be in a matter of weeks, I'm certainly willing to work with the ranking member to put together appropriately redacted entire transcripts. I not only have no objections, I want these records to be public. But I think you would agree, as someone who has done a lot of transcribed interviews, that if everyone is able to see what we're asking everybody else, it often has a very adverse effect. So I would hope that you would take in good faith that I am making a commitment here that to release in the entirety. I welcome you going through and finding selected information that you believe is appropriate to make any case you want to make, either in the proceeding here today or in others, but that you refrain from putting these in their entirety until we have concluded our interviews, which I hope to be soon, and of course, discovery of such information as the simple request we have for Lois Lerner's, and I yield back.
I want to thank the gentleman for yielding. Mr. Chairman, I understand everything you said. As a matter of fact, I've often talked about the release of documents and harming prosecutions and other proceedings. So I'm very much aware. That's why I made a part of my unanimous consent request that the Chairman be allowed to redact whatever you wanted to redact. And the reason why I made the request is because I think the public needs to have this information. It sounds like you agree that the public needs to have the information, and I think and I think the members need to have it. I mean, beyond us, that is. So I just want to. I guess we could go on and on, but I mean, can we have some kind of timeline for that, Mr. Chairman?
I thank the gentleman. If you further yield, I certainly, once we have concluded our transcribed interviews, and there are a few more to go, and we have received the key documents that we told the Commissioner that I'm prepared to work with you on this release. I would say that if your unanimous consent would be that all members of Congress have in-camera access to all these documents, I certainly could support that at this time so that every member of Congress would have full access to see all of these documents, including an in-camera review, including bringing key staff in to help explain it.
All right.
Mr. Chairman,
Yes.
I object and can continue the objection.
The gentleman objects. The unanimous consent. We go to the gentleman from Michigan, Mr. Bentivolio, next.
Thank you very much, Mr. Chairman. Documents and testimony received by the committee show that Mrs. Lerner appears to have had a bias against conservative and Tea Party groups. Can we have a slide, slide 1, perhaps? Okay. According to one witness interviewed by the committee, Mrs. Lerner ordered the IRS to rename the Tea Party cases to something else because she felt the term Tea Party was just too pejorative. Think about that. What is pejorative about the term Tea Party? Nothing other than Mrs. Lerner's personal negative opinion about the Tea Party movement. Slide 2, please. According to one email received by the committee, Mrs. Lerner called the Tea Party cases very dangerous. What is so dangerous about tax-exempt applications? What is so dangerous about Tea Party groups? Nothing, other than they do not correspond to Mrs. Lerner's beliefs. Slide 3, please. Another email shows that Mrs. Lerner hoped the FEC will save the day from anonymous donors giving to Republican Senate candidates. Why would the FEC need to save the day from lawful donors giving to candidates for office? I support the resolution to hold Mrs. Lerner in contempt of Congress for her refusal to testify before this committee. As an institution and as the elected representatives of the American people, we must hold her to account and continue to insist that she provide all information about the IRS targeting. The committee's extensive investigation shows that Ms. Lerner was a central figure in the IRS targeting. As we have heard, Ms. Lerner directed the Tea Party applications to be put through a multi-tier review and delay. Ms. Lerner specifically asked by name for the tax-exempt application filed by Crossroads GPS, a prominent conservative 501c4 applicant. And the Ways and Means Committee released extensive documentation showing how Ms. Lerner subjected conservative groups to extraordinary scrutiny. Beyond these facts, we must hear from Ms. Lerner to understand why she engaged in her actions. Slide 4, please. Another email shows that Ms. Lerner viewed Tea Party groups as fundamentally different from other nonprofit, saying that they are itching for a constitutional challenge and not part of your father's exempt organizations. Mr. Chairman, Lois Lerner's apparent bias likely played a large role in the IRS systematic scrutiny and delay of conservative-leaning tax-exempt applicants. The committee needs her testimony to understand fully how, and more importantly, why, the IRS targeted conservative groups. A vote no is to abandon what I thought were liberal values in order to protect the progressive cause. I urge my colleagues to support this resolution. Thank you, Mr.
Would the gentleman yield to Mr. DeSantis?
Yes, sir. I yield.
Thank you. Just as a prosecutor, anytime I was prosecuting a case, if I would look at the defendant, I'd wonder, is he going to testify or not? Most of the time they don't. But when they do, when they walk up there and take that stand, I know I'm going to get my crack at cross-examination. Never in my life have I seen a defendant get to take the stand, make 17 different factual assertions proclaiming their innocence, and then go sit down without us being able to ask questions. And that's essentially, and this is different than a criminal context, but to me, the criminal context is the most serious. That would be the one that would have the most protections. But I think what Lois Lerner was trying to do, she's trying to have it both ways. When you take the Fifth, it's not going to be used against you in a criminal case, but there is a reputational cost in society that's associated with that. If your neighbor learns you took the Fifth Amendment, most people are going to say, well, gee, why wouldn't you just testify what you did? What are you trying to hide? Whether that's fair or unfair, I think that's just the reality. So here's Lois Lerner. She's a high government official. She's got a six-figure salary. At the time, she thought she may have had good job security. So she wanted to come in here, address the harm that would come to her in terms of her professional reputation and personal reputation by proclaiming her innocence, making 17 different factual assertions, and then taking the Fifth Amendment so she could not be held accountable on her actions in this position, thereby protecting her six-figure salary, her position with the government. You can't have it both ways. She clearly waived her Fifth Amendment right. And this idea that somehow she's a victim, she's a very sophisticated party who is directing a lot of very questionable activity. For me, the victims are the people who were targeted for simply trying to exercise their God-given constitutionally protected rights to engage in political speech and to petition the government for the redress of their grievances. And I yield back.
I thank the gentleman. The gentleman from Tennessee is recognized for 5 minutes. Mr. Cooper.
Thank you, Mr. Chairman. I would like to yield 2 minutes to my friend, Mr. Lynch.
I thank the gentleman for yielding. I'd like to speak in support of Ranking Member Cummings' request. This investigation has been characterized by highly politicized statements by the Chairman and some of his colleagues on the other side of the aisle, followed by leaks of cherry-picked transcript excerpts to support their partisan agenda. On June 2, 2013, Chairman Issa released selected excerpts of these transcribed interviews with IRS employees on CNN, the State of the Union. In response to the partial release of these excerpts, the host stated, and I quote, "Chairman Issa, why don't you put the whole thing out? Because you know our problem really is here, and you know that your critics say that Republicans, and you in particular, sort of cherry-pick information that go to your foregone conclusions, and so it worries us to kind of put this stuff out. Can you not put the whole body of transcripts out?" During that interview, Chairman Issa promised, and this is also a quote, "These transcripts will all be made public," close quote. Despite the Chairman's promise, in the subsequent 9 months, he has not released the transcripts. Instead, time and time again, he has continued to take portions of the transcript and selected documents out of context and leak them to support his partisan inaccurate narrative. At least a dozen times in the past year, the Chairman has released cherry-picked portions of these transcripts. That's on top of denying the ranking member and Democratic members from even speaking. That includes shutting off the microphones of any other point of view that varies with his own. It is time to live up to the promises that we have made to deliver the facts, all of the facts, to the American people. It is time for transparency and for releasing all of the transcripts. This is an extraordinary step for our committee to take, but we need to take it. Releasing these transcripts will increase the transparency and integrity of our investigation, the Oversight Committee, and the IRS. Almost 1 full year after we began investigating the actions of the IRS, it's time the American public receives the unvarnished truth. I yield back to the Chairman.
Let me reclaim my time here.
Mr. Cooper.
I yield my remaining time to Mr. Cartwright.
Thank you, Mr. Cooper. I want to add my voice to those in support of the motion of the ranking member to release the transcripts. I also want to add that the Chairman of this committee has repeatedly given hand-picked reporters an opportunity to read entire transcripts. For example, last June, USA Today reported that Chairman Issa allowed its reporters to review the full transcript of IRS official Holly Paz. The Associated Press also reported that it had, quote, reviewed transcripts from 3 interviews with Paz and 2 agents, Gary Muthert and Elizabeth Hoffaker, unquote. Finally, the Chairman has relied extensively on the interview transcripts and the various staff reports that he has published since this investigation has begun. In fact, the report cited in the contempt resolution cites and even quotes from select transcripts of IRS personnel. The Chairman has already crossed this bridge, and we simply and plainly submit that what's good for the goose is good for the gander. If you're going to release part of them, you ought to release all of them. If you're going to release all of them to some people, you should release all of them to all people. And I yield back to Mr. Cooper.
Would the gentleman from Tennessee yield?
Yes, Mr. Chairman.
I appreciate it. I'm not sure that the gentleman from Pennsylvania heard me when I reiterated and expressed that We would certainly welcome all members of Congress reading these documents, and the minority has every right to select documents and use it in producing their positions. We encourage just exactly that. So hopefully people would understand the goose and gander in this case, Mr. Cooper and Mr. Cartwright, is, of course, go ahead and use these documents, but to provide a roadmap at a time in which the IRS has refused to give us the documents so simple as Ms. Lerner's emails. We only learned yesterday that Ms. Lerner's emails included the kind of communications where she helped target Crossroads GPS and others. These are new discoveries, and these are discoveries in some cases in which excess redaction and documents not provided to us are the very reason that we cannot conclude this hearing. So I thank the gentleman from Tennessee for his kind yielding. The gentleman yields back. At this time, we go to the gentleman from Texas, Mr. Farenthold.
Thank you, Mr. Chairman, and I'll be brief. It's important that we get to the bottom of this. I don't believe for a second that this stopped with Ms. Lerner and that there are other people involved. How we get there through contempt, offer of immunity, we just need to get there. And I'm willing to go forward with this contempt proceeding because I think it's one of the tools in our toolbox to get there. The Ways and Means Committee has referred Ms. Lerner in this matter to the Department of Justice. I don't believe for a second that Eric Holder, who is also in contempt of this body for failing to comply with this committee's subpoenas on Fast and Furious, is going to prosecute that. But we do need to move forward with what we have in our toolbox to fulfill our constitutional duty to get to the bottom of this. The American people deserve to know, and I'm going to support this. I yield back.
Will the gentleman yield?
Yes, I will. Yes, I will.
Mr. Chairman, just real quickly, I know we're about to conclude here, and I wanted to just, for the record, explain my objecting to this, the motion by the ranking member. I have no problem, and I think the Chairman stated my position that we can release these documents. I might say, too, having been on this committee longer than anybody else, each side does use this information. I remember very well when Mr. Cummings, just a few weeks, and we interviewed one or two witnesses, Mr. Cummings went on national television and said, there's no evidence, we need to close this down. So each side does use that. We aren't finished. We have additional witnesses that we want to get the rest of the information. We have about a half a dozen major people we haven't gotten the emails from. So we want to do this in a proper way. And let me say finally, too, this chairman opens every meeting, and he cites something every time consistently, that we have a responsibility in this committee as the chief investigative body of Congress. There's no other committee like this. And there's no other issue I've seen in my 20-some years that has so riveted the American people. Because all of us, whether it's a member of Congress or the lowest citizen out there, lowest paid individual, have to deal with the IRS. And this has shaken the core of fairness and understanding. And then it deals with trying to manipulate an election. I mean, the evidence we have so far is very clear. We just wanted to hear from some of those. Again, the rest of the people, we can't hear from Ms. Lerner. She's being held accountable by this committee. But we have that important responsibility to the American people. They're out there working like dogs today. They sent us to find out what's going on in these agencies, and that their elections that they hold in the highest level, that's the whole basis and foundation of this government, are not skewed, are not manipulated. We have an important responsibility. We've got to keep that. And please don't demagogue the chairman. He's done a very good job. You know, what is it, in logic, college logic, argument ad hominem, I forget the hominem, yeah. When you attack the man, not the argument, and all these other diversions. I know you have a job to do on the other side, but we have a job to do for the American people, and I yield back the balance.
Would the gentleman from Texas further yield?
I'll yield to the chairman, of course.
Thank you. I want to be brief because I don't expect this to go much longer. One thing that I want to make sure is in the record is refusal to testify and being held in contempt can be resolved by an agreement to testify. If Ms. Lerner wants to proffer, my inbox is open every day for her lawyer's proffer. If Ms. Lerner, as we understand, has testified before the Justice Department without immunity and given information, if the ranking member would like to join me in requesting again that the Justice Department provide that to us, it might in fact negate the need to have her come before us. They may have asked the very same question. But until questions which we believe are directly on point to testimony she gave, well represented by counsel, and particularly the testimony after she invoked, is not being provided, we believe, I believe, and I believe the committee will vote that we have little choice. So I want to make sure everyone understands from my opening statement, all we want is the truth. She has statements she could give us. She has made half of a statement available. We'd like to know the other half of the story. And I ask all members to consider that that still be the goal of this committee. And I thank the gentleman for yielding. Does anyone else seek recognition? You've already been recognized. The gentleman from Nevada is recognized.
Thank you. I speak in support of the ranking member's request because after 10 months of cherry-picked quotes and baseless accusations, it is time for the Chairman to make good on his promise to publicly release the full transcripts in this investigation. For the past year, Chairman Iss's central accusation has been that the IRS engaged in political collusion directed by or on behalf of the White House. In fact, before the committee received a single document or interviewed one witness, Chairman Issa went on national television and stated, quote, "This was the targeting of the President's political enemies," unquote. That claim has been debunked soundly and repeatedly by the facts. Mr. Chairman, releasing these transcripts will not harm the criminal investigation of Ms. Lerner because Ms. Lerner has already met with Federal prosecutors. On March 5th, Ms. Lerner's attorney told reporters that within the last 6 months, Ms. Lerner's, quote, "sat for a long unconditional Q&A with prosecutors and members of the Inspector General's staff." If anything, the release of this committee's interview transcripts could actually aid the Department of Justice in its investigation by providing the agency with more complete and detailed picture of the underlying conduct at the IRS. And that is ultimately what my colleagues on the other side say they want. If you want the facts, then why not release the transcripts? Mr. Chairman, if there is nothing to hide, why not release the transcripts? Not just to us as individual members, to the public. This is about transparency. Is there something in those transcripts that you believe do not support your position? If so, let the public see it. That is what they expect. Not one of the 39 witnesses that have appeared before the committee indicated that the White House directed or was any way involved in IRS employees' handling of applications from Tea Party groups. And yet, Chairman Issa has continued to leak selected excerpts from the committee's interviews and withhold portions that directly contradict his public accusations. For example, in June of last year, Chairman Issa leaked portions of an IRS tax law specialist interview to support his conspiracy theory of political targeting. What the Chairman chose not to make public was the portion of her transcript where she dismissed his chief allegation. When asked if she saw any evidence of a plot to, as the Chairman claimed, quote, "target the President's political enemies," this Republican IRS employee said, quote, "No, not at all. That's kind of laughable that people think that. No, not at all. This is purely cases that unfortunately Cincinnati didn't have enough guidance on. That C4 area is very, very difficult area and there's not much guidance. And so the lingering length of time, unfortunately, was just trying to apply the law to the specific facts of each case. Let me repeat," she said, "it's kind of, quote, laughable that people think that." Perhaps the Chairman is more concerned that the release of these transcripts will give the public a roadmap to the truth behind this whole partisan rhetoric. Let's end the partisan bickering. Let's provide the facts. Are you afraid of transparency? Is there something in those transcripts that the public doesn't deserve to know? It will not hurt the criminal investigation. In fact, it may actually help the Department of Justice. I would like to yield my time now to Representative Clay.
I thank my friend from Nevada for yielding, and I want to speak in favor of the motion because the American public deserves transparency. In an investigation that Chairman Issa has marred with partisan attacks and selected releases of interview transcripts. And, you know, I find it incredulous that my friend from Florida talked about this is about election integrity and protecting elections and stopping the manipulation of an election. Where was that resolve for protecting integrity of elections after the 2000 hijacking of a national election? It certainly wasn't in this room. It wasn't on this committee. And so why?
The gentleman from Nevada's time has expired. All time. No, if no further members seek recognition and a sufficient quorum being present, the question is unfavorable reporting, contempt, the report to the House. All those in favor signify by saying aye. 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 Any opposed, no? No. Clearly, in the opinion of the Chair, the ayes have it. The ayes have it. The clerk will call the roll.
Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Mica? Mr. Mica votes aye. Mr. Turner? Mr. Turner votes aye. Mr. Duncan? Mr. McHenry? Mr. McHenry votes aye. Mr. Jordan? Mr. Jordan votes aye. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Walberg? Mr. Walberg votes aye. Mr. Lankford? Mr. Lankford votes aye. Mr. Amash? Mr. Amash votes aye. Mr. Gosar? Mr. Gosar votes aye. Mr. Meehan? Mr. Desjardins? Mr. Desjardins votes aye. Mr. Gowdy? Mr. Gowdy votes aye. Mr. Farenthold? Mr. Farenthold votes aye. Mr. Hastings? Mr. Hastings votes aye. Mrs. Lummis? Mrs. Lummis votes aye. Mr. Woodall? Mr. Massey? Mr. Massey votes aye. Mr. Collins? Mr. Collins votes aye. Mr. Meadows? Mr. Meadows votes aye. Mr. Bentivolio? Mr. Bentivolio votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Cummings? Mr. Cummings votes no. Mrs. Maloney? Mrs. Maloney votes no. Ms. Norton? Mr. Tierney? Mr. Clay? No. Mr. Clay votes no. Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper? No. Mr. Cooper votes no. Mr. Connolly? Nay. Mr. Connolly votes no. Ms. Spear? No. Ms. Spear votes no. Mr. Cartwright? Mr. Cartwright votes no. Ms. Duckworth? Ms. Duckworth votes no. Ms. Kelly? Mr. Davis? Mr. Welch? Mr. Welch votes no. Mr. Cardenas? Mr. Horsford? Mr. Horsford votes no. Ms. Lewin Grisham? No. Ms. Lewin Grisham votes no. Mr. Meehan? You are not recorded. Mr. Meehan votes aye.
Does anyone else seek to be reported? The clerk will report.
On that vote, sir, there are 21 yeas, 12 nays.
The ayes have it. The ayes have it. Contempt report is ordered, reported to the House. Without objection, the staff shall be authorized to make necessary and technical conforming changes to the report.
Mr. Chairman, I ask for the requisite number of days.
Without objection, so ordered. Without objection, we stand adjourned.